Hello and welcome. Hello and welcome. Permit me to say good morning, good afternoon, good evening, and good night to you, depending on your time zone. I am Pst Maxwell Nnawuihe. This is our enlightenment broadcast. This very enlightenment broadcast borders on the injustices that is being meted against Nnamdi Kanu, the leader of the indigenous people of Biafra, who has been held in the DSS dungeon in Abuja, Nigeria for the past 2 years, going to 3 years. By the month of June this year is going to be exactly 3 years that he has been extraordinarily renditioned from Kenya to Nigeria under what is called extraordinary rendition, which is an international crime when it comes to bringing somebody from a different country, from another country, to a particular country to face trial. What is expected to be done according to legal international practices, international law? What is expected is extradition, not extraordinary rendition. Extradition was the process that is approved, that is in the international norm, best practices. If you want to bring someone from another country to face trial in the home country or in a country where you did or you said that the person committed a crime, if there is any crime that is committed, whether it is allegation or it is beyond every reasonable doubt, which shall be proven in the court of competent jurisdiction, you want to bring that very person, the accused, back to the country that you claim he or she has committed a crime. You follow what is called the process of extradition. This has been explained several times, not just in our enlightenment broadcast, but in every other broadcast and discussion, interactive sections regarding the very case of Nnamdi Kanu before the eyes of the law. Just like the United Nations judgment said, Nigeria broke what they called about 16 Cohen laws, 16 at a stretch, just to make sure that they bring Nnamdi Kanu back to Nigeria, force him into the court, and possibly convict him in their court. Unfortunately for them, God really worked very hard to make sure that that very evil and illegal means of bringing Nnamdi Kanu to Nigeria did not see the light of the day. They couldn't jail him till today. So this enlightenment broadcast brings to the knowledge of our audience and the people of Biafra and the Igbo people, and by extension, the Nigerian people, more especially those that love justice and equity. This is a precedence that everyone should work hand in hand to make sure it doesn't take place. It's a very wrong precedence, because if the Nigerian people, whether you are affected now or not, directly or indirectly, whether you are not affected or you're affected, if you allow it to see the light of the day, if you allow it to stick, if you don't rise up in unison to question this very process, this very illegal process of bringing someone to fetch trial in a court in Nigeria, it is Nnamdi Kanu today, it may be you tomorrow, it may be your father tomorrow, it may be your uncle tomorrow, it may be that very person that your destiny is connected to his or hers tomorrow. Remember, when lawyers go to the court, there is what is called the citation of authority. The citation of authority happened to be the citation or bringing to the knowledge or before the court and the judge what has happened in another case that is similar to the case that has been tried in such a court. And they will cite Nigerian government versus or FG versus Susan Soso person, or Susan Soso state versus Susan Soso person, or Susan Soso person versus Soso and Soso person. And they will quote the court and they will quote the law and they will quote the date of that very legal proceeding and the judgment of the judge. It is called authority. They have cited authority. That authority happened to be legal precedence. As at the time that that very legal process was going on, if the process was not according to the law and the people did not challenge it, and the judge had its way in ruling in such a matter that is contrary to the law, it becomes a very bad legal precedence, and it will become authority that other lawyers are going to cite in the court when a similar case like that is being judged. And it may be used as a yardstick to perpetrate injustice. So when this happens, you discover that there is a repeat of a cycle of injustice in the court and the legal precedents against different persons. But it started with one person. This is why this very matter is very, very critical. It is very, very important that you understand what is actually going on and lend your own voice. Stand very, very uprightly. Do not cow and do not allow yourself to be blackmailed into silence. Our focus today is follow UN templates to release Nnamdi Kanu. This is for the lawyers. This is for the new legal team. There's a new legal team that is now representing Nnamdi Kanu. Of course, they have made it very clear that they cannot allow Nnamdi Kanu to be subjected to a legal proceeding or trial that cannot be fair, where his fair trial will not take place. Such a process that will not guarantee a fair trial. But this was exactly what I said on the 15th of December 2023. Immediately, the Supreme Court ruled and gave that very judgment. I was on air broadcasting on my YouTube channel, and I told the world that here comes the end of the court case of Nnamdi Kanu, his legal proceedings in Nigeria. His legal proceedings has ended. I announced it and I said it very loud and clear on air, live. They were telling us that very day after the court, during the press briefing, that the case has been remitted back to the High Court, that they were asked to go back to the High Court of Nigeria, which is the Court of Justice Binta Nyako, to continue with the case. Whereas the Supreme Court of Nigeria is the apex court, the highest court that is created by the Constitution of Nigeria, where legal matters comes to an end. Every legal proceeding that began from the industrial court, that began from the magistrate court, that began from the customary court, that began from the state high court, the state court of appeal, down to the federal high court, federal court of appeal. All these legal proceedings, regardless of where they started, as long as they get to the Supreme Court, that is the highest. That's why it's called Supreme, the Supreme Court. That would be the end of the case, whether it is in the favor of the appellant or it is in the favor of the defendant. That comes the end of the case, because litigation must have a beginning and litigation must have ending. It ends at the Supreme Court. But when it got to the case of Nnamdi Kanu, they asked them to go back to the Federal High Court, which was a subversion of the Constitution. And I've cited example in different fora, in my different broadcasts, the example of P2B and Atiku Abubakar in the presidential election of 2023. They went to the election petition tribunal, and it was not favorable to them. They lost the case. They called it the court of the first instance. They proceeded to the Supreme Court of Nigeria. And when they got there, the Supreme Court was not in their favor. Immediately after the court gave the ruling, Atiku Abubakar came out and addressed the press and addressed all his teaming supporters that he had decided to rest the case because the Supreme Court has given its verdict, and that is final. Mr. P to be the same. Their case ended at the Supreme Court. And you know that the 2023 presidential election was the most contested election. It was so contested. It was so critical in the life of Nigerians that they hoped for the birth of a new Nigeria through that very election. It was keenly contested. But when the legal matter got to the Supreme Court, it ended. It ended. Atiku Abubakar and Mr. P2B, they're all hands off. That is how it's supposed to be. So I announced it at the end of the Supreme Court judgment of Nnamdi Kanu that that is the end of it. But some people didn't quite understand. Now, the legal team continued and filed a process at the High Court after the Supreme Court judgment. They filed for bail. The case was adjourned without a date. Later on, they fixed the 26th of February for the hearing of the bail application, which was actually carried out. They had the bail application. Now, they adjourned the case to the 19th and the 20th of March for ruling to determine if the Court of Justice Binta Nyako is going to grant the bail application that was filed by the new legal team of Nnamdi Kanu. And I was still shouting that I am not going to broadcast any other court proceeding of Nnamdi Kanu in Nigeria because his court case had ended at the Supreme Court. And I maintained it. I didn't broadcast it live. I have been broadcasting all his legal proceedings and court appearances live on air across my different platforms. But that very day, as a man of God and someone that is so circumspect, that is in tune with the workings of the judiciary and what the Constitution says, I knew that that very case has come to an end at the Supreme Court, even though it is not what is being propagated by some people or some persons. The former leader of the legal team of Nnamdi Kanu, Barrister Fanya Jofo, rightly said in a press interview that it is the right thing to do, that they have to go back to the High Court. And I said no. When this new legal team filed or decided to go to the Federal High Court to continue with the trial of Nnamdi Kanu, I said it's a wrong move. You people have to boycott the court. Anything court in Nigeria, boycott it and stand on the UN template. Follow the UN template, the template that is handed down, which actually influenced the judgment of the Appeal Court of Nigeria on the 13th of October 2022. And it also influenced the judgment of the Supreme Court of Nigeria, whether they believe it or not. It influenced it. The UN judgment played a very major role in determining that very Supreme Court judgment of Nigeria on the 15th of December 2023 in the favor of Nnamdi Kanu. The only difference was that the Supreme Court did not say release Nnamdi Kanu unconditionally and let him go. That is the only thing missing in that very judgment. They told the same part of this of the UN judgment. The UN judgment condemned all the process by which Nigerian government brought Nnamdi Kanu to fetch trial in Nigeria. The same thing was what the Appeal Court did. Appeal Court is a Nigerian appeal court. The Supreme Court did the same, condemned all the processes by which Nnamdi Kanu was brought back to Nigeria to face trial. The only thing missing was that the Supreme Court didn't say release him unconditionally and pay him adequate compensation. But every other ingredient that is so critical from the UN template was seen in that very ruling of the Supreme Court of Nigeria. It was in the favor of Nnamdi Kanu. I don't want to say more than this because it's very important we continue with the enlightenment broadcast. I am bringing to the screen this very document important reference. Follow the UN template. The legal team of Nnamdi Kanu should do. Let them follow the UN template. If you follow the UN template, it's going to do you a whole lot of good, a whole lot of favor. It is going to reduce your legal stress, except you hate or you don't like what the UN delivered as a ruling in the favor of Nnamdi Kanu, which I know you won't. You won't because it helps you. It helps you to scale through. the legal hurdles in Nigeria. Before us is a very powerful template from the United Nations for the release of Nnamdi Kanu. We begin to read from the paragraph 40. We have been reading from the paragraph 1 and explaining some of the paragraphs, some of the words there, putting them in very proper context, proper perspective as well. We are going to continue from the paragraph 40. I am Pastor Maxwell Nnawuihe, if you're just joining us. The working group considers that following his arrest on 19 June 2021, Mr. Khan was subjected to enforced disappearance as he was taken to and held at an undisclosed location and his whereabouts were unknown. He remained forcibly disappeared throughout his extraordinary rendition to Nigeria in violation of Mr. Kano's rights under Article 9, Section 1 of the Covenant. These are the things you must be aware of. Don't ever forget it. The working group recalls that enforced disappearances are prohibited, prohibited by international law and constitute a particularly aggravated form of arbitrary detention. Aggravated form of not just arbitrary detention, but aggravated form of it. Very, very severe, very, very bad, very, very condemnable in the eyes of the law. Paragraph 41. Moreover, recalling the uncontested allegations that Mr. Kanu was taken to a secret location, the working group reiterates that holding persons at secret, undisclosed locations and in circumstances undisclosed to the person's family and lawyers, as was the case with Mr. Kanu, violates their right to contest the legality of the detention before a court or tribunal under Article 9, Section 4 of the Covenant. It entails a willful refusal to disclose the fate, a willful refusal to disclose the fate or whereabouts of the persons concerned or to acknowledge their detention. This lacks any valid legal basis under any circumstance. Under any circumstance, there is no reason that the Nigerian government will give in order to substantiate or defend the extraordinary rendition of Nnamdi Kanu from Kenya to Nigeria that has a legal basis, whatever circumstance that must have necessitated it has no legal, this lacks any legal basis under any circumstance. I'm not the one saying it. It is the United Nations saying it. It is not America. It is not Germany. It is the United Nations speaking for the whole world in the favor of Nnamdi Kanu and in the condemnation of the act of the Nigerian government and that of the Kenya. Judicial oversight of any detention is a central safeguard for personal liberty and is critical in ensuring that detention has a legitimate basis. It must have a legitimate basis. In the case of Nigeria detaining Nnamdi Kanu, it has no legitimate basis. In the circumstances attending the detention of Mr. Kanu at an unknown location, the working group finds that his right to an effective remedy under Article 8 of the Universal Declaration of Human Rights and Article 2, Section 3 of the Covenant were violated. They were violated. He was also placed outside the protection of the law, a violation of his right to be recognized as a person before the law under Article 6 of the Universal Declaration of Human Rights and Article 16 of the Covenant. Paragraph 42. The working group also considers that Mr. Kanu's time in detention following his arrest constitutes pretrial detention. It constitutes pretrial detention, which violated the prescriptions of Article 9, Section 3 of the Covenant, insofar as Mr. Kanu was not presented before a judicial authority within 48 hours and no individual assessment of the appropriateness of his pretrial detention took place. There was no individual assessment of the appropriateness of his pretrial detention that took place. To know whether his pretrial detention was appropriate, none of such assessment took place. None. Zero. It was like a martial act. Just like in a military regime of martial, or just like in a mafian country, drug lords fighting against themselves. Look at the paragraph 43. The source asserts, the source here in reference is Bruce Crane, the international attorney of Nnamdi Kanu and IPOB. The source stated, asserts, and the government does not contest that on or about 29 June 2021, Mr. Kanu was subjected to extraordinary rendition to Abuja, Nigeria, with no prior judicial hearing before a judicial or administrative body. The source emphasizes that Mr. Kanu was not given access to counsel and was denied any judicial proceeding altogether while in Kenya. The source notes, Bruce Fein notes, that according to Nigeria's Attorney General, which happened to be the former Attorney General, which is Abubakar Malami, Mr. Kanu was apprehended and transported to Abuja with the cooperation of Nigerian intelligence officials and Interpol. When he was speaking apprehended, he was so proud and so bold, but he never knew that United Nations is going to cross-examine, is going to investigate the process by which they brought Nnamdi Kanu to Nigeria. If he knew, he wouldn't have made such a statement. Of course, he is no longer the serving Attorney General of Nigeria. We have a new Attorney General of Nigeria, Yoruba man. Look at the paragraph 44. The source claims that in the present case, there was no fair trial or fair and public hearing concerning Mr. Kanu's removal from Kenya to Nigeria. The source stresses that involuntary expulsion to a foreign state without a hearing by judicial authorities does not conform with due process considerations. That was what Bruce Fein said. That was exactly what he told the United Nations on behalf of Nnamdi Kanu. And the United Nations accepted it. And they now gave a ruling that has become a very important and very, very, very clear template that the legal team of Nnamdi Kanu must continue to follow. Those that are speaking on behalf of Nnamdi Kanu, be it on Radio Biafra, be it on all IPOB platforms, they must be preaching, they must be making strong emphasis, they must be hitting the hammer on the head of the nail. The nail that nailed the coffin of this case is the United Nations template. It is the United Nations judgment. Everyone that truly loves Nnamdi Kanu must be speaking about this very judgment. If you don't do it, it doesn't matter who you are, even if you are his wife, you are his siblings, if you are not propagating, if you are not preaching this United Nations judgment, compelling the Nigerian government to comply with it, you are not indeed a true lover and a true supporter, a true follower, a true loyalist of Mazen Nnamdi Kanu. You can never excuse yourself away from the truth. We must continue. If you are just joining us, this is our enlightenment broadcast. Today is the 3rd of April, 2024. I am Pst Maxwell Nnawuihe. I stand for the truth and I preach the truth regardless of who is comfortable with it or not. Let's go to the paragraph 45. It is clear from the facts as narrated by Bruce Fein, the source, and not contested by the government, that Mr. Kanu was never presented to a court before leaving Nairobi. Instead, he was unwillingly taken outside any legal process and without any legal protection. He was forcibly conveyed from Nairobi to Abuja under an arrangement between the Kenyan and Nigerian governments and with the cooperation of the Nigerian intelligence officials and Interpol, as confirmed by Nigeria's Attorney General, that is, former Attorney General of Nigeria, Abubakar Malami. He confirmed it that they committed a crime. He confirmed it that they extraordinarily renditioned Pst Maxwell Nnawuihe from Kenya to Nigeria. He confirmed it that they forced him down to Nigeria. He confirmed it. Look at the paragraph 46. Please share this broadcast. You are free to share it to your platform. John chapter 8 verse 32 says, "You shall know the truth, and the truth shall set you free." As the working group has previously observed, international law regarding extradition provides procedures that must be observed by countries in arresting, detaining, and returning individuals to face criminal proceedings in another country, and in ensuring that their right to fair trial is protected. This is also an explicating obligation arising from Article 13 of the Covenant, which requires that the person who is to be expelled be allowed to submit the reasons against his expulsion and to have his case reviewed by and be presented for the purpose before the competent authority or a person or persons especially designated by the competent authority. The working group finds that all these requirements were ignored in the present case, and the removal of Mr. Nnamdi Kanu from Kenya amounted to extraordinary rendition. They ignored all the requirements. They ignored it. Kenya ignored it. Nigeria ignored it. And now the United Nations says, yes, you have ignored it, but not for too long a time. You are being held accountable. You are being held accountable for ignoring the very requirement that is very important and internationally accepted. Paragraph 47. As the working group has explained, the practice of so-called renditions, because it is aimed at avoiding all procedural safeguards, is not compatible with international law. I hope you are following. It's not compatible. The working group has previously found a violation of Article 9 of the Covenant and the detention to be arbitrary, where individuals were transferred to another country outside the confines of any legal procedure, such as extradition. We are not allowed access to counsel or to any judicial body to contest, to argue, to challenge the transfers. This is precisely what happened to Mr. Nnamdi Kanu in the present case. That is what the United Nations judgment is saying. The working group therefore finds that Mr. Kanu's arrest and transfer to Nigeria lacked a legal basis and due process of law, in violation of Article 9 of the Universal Declaration of Human Rights and Article 9 of the Covenant. I want to take it again that you may understand. For those of you that are clapping for the Nigerian government, oh, this government is very strong. Oh, Buhari government was so tough. Oh, this government too powerful. Oh, this government is a mafian government. I give it to them. You are happy, you are clapping because Nnamdi Kanu is not your brother, Nnamdi Kanu is not your father, Nnamdi Kanu is not your husband or uncle or nephew or best friend. You are so happy. Look at what the international community is saying. The working group, therefore, finds that Mr. Kanu's arrest and transfer to Nigeria lacked a legal basis and due process of law, in violation, not in agreement, not in accordance with, but in violation of Article 9 of the Universal Declaration of Human Rights and Article 9 of the Covenant, which Nigerian government ratified, which Nigerian government domesticated, which Nigerian government and Kenyan government signed. They signed it and they violated it. Now, look at the paragraph 48. Further, the working group notes that this was preceded by the secret detention of Mr. Nnamdi Kanu, as the working group and other experts have stated regarding state responsibility in joint study on global practices in relation to secret detention in the context of counter-terrorism. Very soon, this very segment of the broadcast is going to come to an end. What are they saying? In joint study on global practices in relation to secret detention in the context of countering terrorism. You want to detain somebody secretly. You don't want to disclose their whereabouts. You don't want their lawyer to know. You don't want their family members to know, because you suspect them to be a terrorist, because you think they are planning terrorist attack or they have been involved in terrorist activities, and you decided to abduct them, you decided to arrest them secretly and detain them secretly to find out more whether it is true or not. That doesn't give room for this. That is what this paragraph 48 is trying to explain. Secret detention involving the denial or concealment of persons' detention, whereabouts, or fate has the inherent consequence of placing the person outside the protection of the law. The person must be protected by the law until convicted, until you are able to convict such a person of any crime. You must not keep that person outside the law, the protection of the law. If you do it, it becomes illegal. If you do it, you are no longer working according to the provisions and the procedures of the law. Nnamdi Kanu was placed outside the protection of the law. We continue. The practice of proxy detention, where persons are transferred from one state to another outside the realm of any international or national legal procedure, rendition or extraordinary rendition, for the specific purpose of secretly detaining them or to exclude the possibility of review by the domestic courts of the state having custody of the detainee, or otherwise in violation of the well-entrenched principle of non-refoulement, entails exactly the same consequence. The practice of proxy detention involves the responsibility of both the state that is detaining the victim and the state on whose behalf or at whose behest the detention takes place. Paragraph 49. Moreover, in its resolution 37/3, the Human Rights Council stressed that no one should be held in secret detention and urged states to ensure that all persons held in detention under the authority were provided with access to the courts and to investigate all alleged cases of secret detention, including under the pretext of counterterrorism, even if it is under the pretext of counterterrorism that they are claiming that they are doing this because it is one of the procedure to ensure counter-terrorism, or they don't want the person to carry out terrorist attack, which they are suspecting that the person wanted to carry out. This is the last paragraph for this very segment. That is paragraph 50. For the reasons articulated, the working group finds that the government of Kenya failed to establish a legal basis for Nnamdi Kanu's detention. His detention and extraordinary rendition to Nigeria was thus arbitrary under category 1. Under category 1. This is very, very important for you to take note of. It is worthy of note what we have just heard, this very powerful template that the United Nations has handed over to the Biafran people, to the Igbo people, to the legal team of Nnamdi Kanu. Very, very important that you follow this very template. It is critical. It is important. Don't dismiss it with a wave of hand. Don't say, oh, it is not within the purview of Nigeria, or that Nigeria has not developed to the extent of complying with some of the international best practices when it comes to legal procedures. Don't say so. Don't say it. Do not join those who are ignorant to say so. If you say that Nigeria is not developed enough legally to adapt or to apply some of these international legal procedures, if you say that Nigeria is not qualified to do so, that Nigeria is not developed enough to do so, why do they have internet? Why do they receive aids from the United Nations? Why? Why do they receive aid? Why do they receive aid? Why do they receive international grants or international aid support from World Bank? Why do they receive monetary support from the World Bank? Why do they receive certain kind of international assistance from the IMF? Why do they do so? If you say that Nigeria is not developed enough to comply with the very international template, the very international law, the very judgment that the United Nations has given in the favor of Nnamdi Kanu, if you claim that Nigeria is not qualified or developed enough to comply with it, why is it that Nigeria is seeking for a seat at the Security Council of the United Nations? Why? Why is it? For the past 20 years, if I'm not mistaken, Nigeria has been clamoring to be given a seat as a country at the Security Council of the United Nations. Nigeria has been working very hard, lobbying and lobbying and lobbying to be given a seat at the Security Council of the United Nations. Why are they looking for a seat? Why do they want the United Nations to give them a seat at their Security Council? For Nigeria to be seated there, for Nigeria to be represented, for Nigeria to have a seat at the Security Council when they cannot comply with the judgment of the same United Nations. Tell me why. When Nigeria, that is signatory to all the treaties, to all the covenant and all the declaration of human rights by the United Nations, Nigeria is signatory to it, Nigeria is party to it, Kenya is party to it, they signed it, they domesticated it, they brought it to become part of the Nigerian laws and constitution. And now this judgment is given on behalf of Nnamdi Kanu. Contrary to what the Nigerian government expected, they don't want to comply with it. But they want the same body, they want the same organization, they want the same United Nations to give them a seat at their Security Council. I bring the very broadcast to an end with this. Watch out for the category 2. God bless you. I am Pst Maxwell Nnawuihe. Goodbye from here. Bye.